So we'll move forward with, let me first do the introduction to all the panelists. And thank you, panelists, for agreeing to spend your time with us and answer a few questions. So the format is going to go like this. I'll do a quick, brief introduction. I'll give each panelist about a minute or so to say anything they want to add to that. Then we're going to jump right into asking them questions. And at some point, we're going to interrupt that and open it up for the audience questions and resume. And we'll see how long we can do this, but we have limited time, both for the sake of time constraint. We'll keep this short. We may not get to all the questions, and I just want to, timid the expectation of that, and I'm sure it's going to be a robust conversation. So the first person I'm going to introduce is Christina. Christina specializes in civil rights enforcement and community outreach. She brings multicultural perspective from her Portuguese immigrant family background and experience providing legal services to vulnerable population before joining the state service. So if I didn't say this, she works with the California Department of Civil Rights in the Education and Outreach Department. That's Christina. The next person is Alan. Alan is a disability rights attorney, Alan Goldstein. He's got 15 years plus fighting for workplace equality. He led federal litigation, creating the first integrated high school sports program for students with disabilities in Illinois, and coached for the 1996 U.S. Paralympic team. So say hello to Alan. And our repeated guest and a wealth of resource on a regular basis is, last but not least, Eli Medrano, as he introduced himself previously. Eli guides state agencies on disability employment program, including LEAP hiring, reasonable accommodation. He's also the subject matter expert on reasonable accommodation and EEO program for CalHR, and offer that counseling to multitudes of state entities. At this point, I'm going to allow each speaker or panelist a minute or so to say anything you like to say to this panel discussion before we move on to the question part. And both Alex and I will alternate the question as we go through this. Christina, you want to go first?
Sure. No, I just want to extend my thanks and my gratitude for being here today. This is my second time getting to speak to this group of folks. So a thank you to Bobby and to Alex. I've been an attorney for 15 years, and I find that this is an evergreen area where folks are interested. This is certainly reasonable accommodations and disability. It represents the greatest, the largest protected class that we see at CRD. And so I just want to acknowledge and honor that this is an incredibly complex, but also not complex area of the law. I want to also thank my co-panelists in advance. Over to you, Alan.
Yeah, thank you.
Okay, well, first I'll describe myself. I'm wearing a purple shirt and a striped tie representing for SEIU Local 1000, my employer. I have no hair and a salt and pepper beard, more salt than pepper. And I'm not wearing glasses for the first time since 5th grade due to recent cataract surgery, which was successful. And I want to thank Bobby and Alex for having me join this esteemed panel discussion. I think the free exchange of ideas is very important. And I freely admit my perspective is warped. I'm sure people get reasonable accommodations for full-time telework all the time, but they have no need to contact me. I hear from the accommodation issues that drag on for months and months and months. I will express some opinions where people may certainly disagree, and I'm happy to talk about that, and some that I think are covered by legal authority. But I encourage anyone on the panel or in the audience to articulate a contrary position and offer their legal support. A robust discussion is always helpful for all of us.
Thank you, Alan. Eli?
Hello, everyone. Good morning again. Christina, I've attended your presentations and delighted to be part of the panel with you. It's nice to meet you. And Alan, it's nice to see you again. Thank you so much for being here. And I look forward to the interaction amongst us and the information that I'll hear from both of you. I feel privileged to be part of this panel, to be sandwiched by two attorneys. I am not an attorney. And so I will speak from the perspective of CalHR, especially in regard to the model statewide policy. And Bobby, if it's okay, I'll read the statement that I prepared in collaboration with my division chief and assistant chief, and it's basically some information about resulting from AB 313. So many of us know that in 2022. The Assembly Bill 313 amended California law and expanded CalHR's Equal Employment Authority. And the government code now states that the department, that's CalHR, shall be responsible for the statewide advocacy, coordination, enforcement, and monitoring of programs described in Subdivision A. And those are basically the EEO programs, including a reasonable accommodation policy. And the government code also states that CalHR shall be responsible for the development of model policies, including a model policy on reasonable accommodation. And in alignment with California law, our office conducted a statewide survey on the status of reasonable accommodation policies and procedures statewide. And we collaborated with stakeholders and legal counsel to draft the statewide model RA policy, which was formally issued in August of 2023. And that model policy is posted on CalHR's public-facing RA webpage and serves as a guide for all state agencies. And when we began this work, roughly 85% of departments had an existing RA policy. And today, 100% of state departments have both a reasonable accommodation policy and established procedures in place. And also beyond policy development, we have continued to engage with RA coordinators, EEO officers, and related professionals through the RA roundtables. Over time, we expanded these conversations to include DEIA professionals, return to work coordinators, and members of the departmental disability advisory committees. And I've seen Bobby attend those roundtables and other DAC members as well, and thereby broadening the exchange of knowledge and best practices across the state. And through these forums and through direct case consultations with departments, we have created greater consistency, awareness, and collaboration statewide. And as I've said earlier, it's a privilege to join this panel of advocates, attorneys, and EEO professionals. And together we share a common purpose, ensuring equal opportunity and equity for applicants and employees with disabilities. As I've said, I'm grateful to be part of this dialogue. And I look forward to the insights and perspectives that we will exchange. And thank you again for giving me an opportunity to deliver that opening remarks. Yeah.
Thank you, Eli. It was a bit longer than I expected. So if we run,
sorry.
All your fault. Blame Eli. All right. So we'll go to question number 1, which I'm going to ask first question to all three of the panelists, and you'll have an opportunity about a minute or two maximum. Please try to keep it short. First, Alan, executive order N2225 issued on March 2nd, 2025 establishes a default minimum of 4 in-person workdays per week. How does this executive order interact with existing collective bargaining agreements that may specify different telework arrangements, such as 2-day in office requirement, which takes precedence over a conflict? This may have been already resolved with the recent side letter agreement that SEIU Local 1000 entered with the state, but I'd like you to respond if there's something else that to be added.
Absolutely. And I'm only familiar with Local 1000's MOU, so I'm not sure if other collective bargaining agreements or MOUs have telework requirements. But I would think, and I'm not 100% sure, but I would think if an executive order conflicts with an MOU, the MOU would likely take precedence. It's a negotiated contract signed by the state that's approved by the legislature. And executive orders cannot trump the law or pre-existing agreements. There's numerous federal and state court cases on that issue. And, as SEIU has a side letter that we go back to 2 days a week, at least until July 1st of 2026. And I think some other unions have similar agreements. The professional engineers in California government, California attorneys, ALJs, and hearing officers and state employees, and the California Statewide Law Enforcement Association, and there may be others I'm just unaware. That's my answer.
Thank you, Alan. Question goes to Christina. While FEHA requires a timely, good faith, interactive process, what constitute a reasonable timeline in CRD's enforcement experience? How does CRD evaluate whether an employer has failed to engage in the interactive process promptly, and what remedies are available when delays occur?
Thanks for the question. I realize also I did not describe myself, so I will do that quickly. I am a middle-aged cisgender woman. I have a lot of hair. I have brown curly hair. I'm wearing black glasses and a vintage blazer that I like very much. So thank you again for the question. I would love for the law to be clear on this. I would love for the law to prescribe a specific time frame. Unfortunately, it does not. It is highly, highly fact specific because we know that reasonable accommodations have to be responsive to folks' disabilities. And disabilities are myriad, right? And they can interact with folks in lots of different ways. The most important thing for us at CRD, what we are looking for, is the timing, right? The timing of how long is it taking to get a response, right? What is the imperative nature of the need, right? Is it something like the example given earlier about needing note-taking technology, where it's an everyday need and it's immediate? So those things are really important. Certainly that could be proved through documenting conversations. The interactive process is ongoing. It is a dynamic process. So documenting each of those pieces of the process, even though that's not technically required, is a very, very good idea for everyone involved. I think that too, something where employers may kind of fall down on their obligations is not using active listening during that interactive process. So not just hearing, well, I'm scrambling all over the place and I have to leave early, because I have to pick up my child from this particular school that they go to that suits their needs, right? An employer might think, oh, well, that's not something they're asking for themselves, but that employee just told you that they're feeling stress and anxiety, right? So if you're using those active listening skills, you may be able to discern a disability or something for which they themselves could request an accommodation. So get creative, everybody. Look at retention, look at happiness, comfort, flexibility, look at all of those things to retain a workforce that is inclusive and that is healthy. I'll say too, lastly, an undue delay in responding. So putting it off because, I don't remember what the process is. Let me go run over here and read this. That may constitute disability discrimination. That may be an undue delay, which is a denial, which is discrimination. Also, a flat out no without any engagement is going to constitute disability discrimination. CRD did not make that rule. A judge made that rule. So, some remedies for failure to accommodate could mean getting the accommodation. It could mean reinstatement, could mean back pay, out-of-pocket expenses, perhaps if the person was providing their own accommodation in the meantime. So those are all things that someone could think about. Coming to CRD is a benefit, though, because we can be really flexible in our mediation process. We can, help an employer develop a thoughtful, reasonable accommodation policy, and then we could monitor its implementation.
Thank you, Christina. Eli, you're next. The question I have for you is, what specific timeline does CalHR recommend for completing the interactive process, and how should departments handle cases where process extend beyond reasonable timeframe?
Thank you, Bobby, for that question. I think that question is reflective of many other people's questions as well. And I do want to say that the model statewide RA policy does not set forth a specific timeline for processing reasonable accommodation requests. And this is consistent with the Fair Employment and Housing Act, which likewise does not prescribe a fixed period or define what constitutes a reasonable time frame. And to my knowledge, and I think this is consistent with what Christina just said, the CRD, the California Civil Rights Department, nor the Equal Employment Opportunity Commission provides a defined time frame for processing such requests. But that being said, I do want to emphasize the fact that departments are required, not just encouraged, to engage in a timely, good faith, interactive process. And this is prescribed by the FEHA. And since each request is evaluated on its own merits and influenced by a variety of factors, the time frame will vary from case to case. I also do want to highlight the fact that the RA coordinator, and this is specified on the model policy, is responsible for actively engaging in the interactive process and responding to accommodation requests as promptly as possible. And equally important is also consistent, open communication between the RA coordinator and the employee. I know I said that earlier, but I do want to say it again because it's such an important component of the interactive process. It's not just a one-way dialogue. It has to be a mutually agreed upon communication and a very active communication about the employee's limitations, the need for accommodation, the anticipated timeline for completion or implementation of the accommodation, and other related considerations. And in terms of options for the employees, employees may file a discrimination complaint, a disability discrimination complaint, internally with their Equal Employment Opportunity Officer. They may also file a complaint in regard to the denial of their RA request. And if after 90 days, the department has not responded, they may file a complaint with the State Personnel Board. And also within 30 days after the response of the department. And also, the other external options are filing a complaint with the CRD or the EEOC. So there are these available options. So, Bobby, that's my response to that question. Thank you.
Thank you, Eli. Alex, you want to take the next set of questions?
Sure. Thank you, Bobby. Thank you, Eli. Next question, Alan. Thank you for being here. Next question is about legal hierarchy and executive orders versus FEHA compliance. So when executive orders potentially conflict with FEHA requirements, what is the legal hierarchy? Must executive orders be implemented in a manner that maintains full FEHA compliance, particularly regarding reasonable accommodations?
Yes, but I'll expand a little more on that. The governor's executive order does not trump FEHA. As in the US, as I learned in 7th grade, even elected officials are supposed to be subject to the rule of law. And both federal and state courts have found executive orders to violate state law and revoke them. Further, I want to point out something important. The executive order references FEHA and reasonable accommodation in 2 places. In the whereas clause, it says, individualized reasonable accommodations processes will continue to remain available. And in the main section, it says, requests for more than 1 telework day per week should be looked at on a case-by-case basis, consistent with existing state policies and governing law. And then I reference parenthetically requests for reasonable accommodations, FMLA, or flexible schedule frameworks. So in my opinion, ignoring the reasonable accommodation provisions in the executive order and having a blanket policy of not allowing full-time telework is problematic, and in addition may actually be violating the executive order because the executive order says you do this on a case-by-case basis. So I think when 4 days in the office is not an effective reasonable accommodation and alternative effective reasonable accommodations are available, that may be discriminatory. And blanket rules And this and other areas may be considered discrimination under FEHA and ADA per the EEOC and courts. EEOC guidance is relevated because FEHA states in the statute that the ADA sets a floor for FEHA and California protections extend beyond that. Therefore, a policy to never allow full-time telework may likely be discriminatory. And I would also like to point out the EEOC has said in guidance that telework experiences during COVID are relevant for evaluating telework post-COVID. And one last thing I want to point out on this, just last week, the California State Auditor came out with a finding on telework in which they wrote a letter to the governor and the legislature saying that they think the one-size-fits-all approach to telework is counter to state policy and may be costing the state as much as $225 million. And that cost estimate does not include benefits to the environment, personal well-being, or cost savings to the employee.
All right, thank you, Alan. Appreciate that. Next question. Christina, nice to meet you again. The question here is about technology and algorithmic discrimination. Your recent presentation on August 6th mentions that hiring technology may have disproportionate impact on applicants with disabilities. Can you provide specific examples of problematic automated screen tools CRD has encountered, and what proactive steps should employees take to audit their hiring technology for compliance?
Yeah, this is a great question, and it's an interesting and evolving area of the law. So the reference to the August 6th presentation, I'm going to drop a link in the chat right here. CRD provides webinars 3 a month, 1 on employment, 1 on housing, and 1 on a special topic. So that's the reference to the presentation. So, and I do talk about screening technology and why that's an issue. There are some regulations that were added to FEHA, the Fair Employment and Housing Act, somewhat recently about technology that might screen folks out. And it's specifically looking at screening folks out based on their schedule. So the AI technology, the artificial intelligence technology can screen applications for things like, can you work at 9 a.m. or can you work on call? And it may screen out folks with disabilities who may not be able to do those things and who could legally, fully within their rights, request a reasonable accommodation so long as they can meet and perform the essential functions of that job. So what employers can do, well, I should say this, that practice is illegal. So having, technology that screens folks out that could screen out folks with disabilities is illegal unless it's job related. So that need to screen, job related, necessary to the business, and the technology includes a way for folks to ask for reasonable accommodations. Right? We know certainly that not everyone is going to be able to participate in an online application process. So if that is the only way that folks can apply, then that employer needs to be thoughtful about advancing ways to make sure that a person can request a reasonable accommodation. That sometimes it depends on the software, honestly. Sometimes it's a matter of, adding a section at the bottom that says, yes, and if you need an accommodation, contact us, email us, whatever the alternative method is. Employers can ask these questions, but they have to be really clear about them. Other than your disability, a medical condition, or religious creed, can you meet the scheduling requirements here? That would be an appropriate question because, again, the FEHA regulations are looking specifically at disability, at medical condition, and at religious creed. That is where the scheduling issues tend to come up, right? Folks who practice different faiths and may have scheduling conflicts as a result. So most recently, I've gotten feedback about webinars related to age discrimination, and I bring that up because it sometimes does overlap with disability discrimination. So what I have heard is that folks are being screened out based on the year they graduated college. So that's a way to essentially discriminate against folks who are 40 or older, potentially, depending on what screening they put in there. And so that is something that I've heard. I don't know if CRD complaints have come in, but I've heard that from folks on webinars. People are sending, in the chat and questions and things of that nature. So employers, closely read your user agreement, closely read the terms and conditions and the features to make sure that minimally it does provide folks an opportunity to request a reasonable accommodation if that online tech does not work for them.
Excellent response. Thank you, Christina. Appreciate you. Next question, Eli. I see you quite often, so hello again.
Hello.
Our question for you is about interim telework operational guidelines. Can you provide more detailed guidance on what constitutes operational feasibility when departments are deciding whether to offer interim telework during the accommodation review process?
Good question. Thank you, Alex. I can't promise a detailed guidance because I already got in trouble with Bobby on my opening statement, but hopefully the information I'll provide is sufficient. So 3 months ago, CalHR published the RA best practices and FAQ document, and that's on our webpage as well, and we'll put it in the chat for those of you who have not read the document. And this document presented temporary telework as a tool state departments can utilize to help manage a significant volume of incoming RA requests. And what constitutes operationally feasible, of course, depends on the department, the essential functions of the employee, and the operational needs. And the department may consider factors that include, but are not limited to the following: business needs. Can the employee fulfill the critical duties of their role remotely or with minimal adjustments? Uncompromised service delivery. Think of duties that are public facing, security sensitive, or site specific. Third point, managing resources and supervision. Does the department have the tools, technology, and oversight capacity to support telework on a temporary basis? And then the fourth point of consideration that we recommend is no significant cost or disruption. Would the interim arrangement create an undue burden or expense, workload redistribution, or operational continuity? So in other words, if interim telework allows the employee to stay engaged in meaningful work while the RA request is being processed, and it does not impose undue hardship, it may be considered operationally feasible. It is up to the departments to make that determination. Thank you again, Alex, for the question.
Thank you. I'm going to present the next question to Alan. Alan, are commuting limitations stemming from an employee's disability considered within FEHA's scope of reasonable accommodation requirements? How should employers evaluate accommodation requests related to transportation barriers caused by disabilities?
Bobby, thank you for that question. I've been waiting for that one. First, I want to explain some acronyms I use when I say FEHA, or the panel uses it. That's the Fair Employment Housing Act, California state law regarding discrimination. The ADA is the Americans with Disabilities Act, the federal law regarding disability discrimination. And the EEOC is the Equal Employment Opportunity Commission, the federal agency, which is now a bare bones agency that investigates federal discrimination issues. So with all due respect to Ms. Gomez, and I wish she was here, I disagree about commuting issues, and I would be certainly interested in seeing case law that supports her position. I believe that commuting issues need to be evaluated like all reasonable accommodation issues, whether there's an undue hardship analysis, whether there's an undue hardship defined as significant difficulty or expense. But I believe those limitations do need to be accommodated. I cited one case in the chat, Revell versus Hewlett Packard Entertainment, and someone commented, well, that case doesn't count because it's not about telework. And I think there's a two-step process there. One, does the limitation in commuting need to be accommodated? I think the answer is yes. And two, is telework an appropriate, reasonable accommodation, or is there an undue hardship? And that's a case-by-case basis. So I think, in Ravel, the court said the Ninth Circuit has held, however, and the Ninth Circuit is the federal circuit court that covers our state. And again, cases under ADA are appropriate because FEHA goes beyond ADA. So the Ninth Circuit has held, however, that an employer has an obligation, and I quote, to accommodate an employee's limitations in getting to and from work under the ADA. And they cite another case, Livingston versus Fred Meyer Stores. And I have another case, Sargent versus Litton Systems, which is a California case under state law, and it rejected an argument that an employer had no duty under FEHA to accommodate a disabled employee who experienced pain in driving to work. And I have another case, Lauer versus DNC Parks and Resorts, which discussed Weisinger versus Auto Club, where it found that telling the jury that it could not consider a plaintiff's commute in deciding reasonable workplace accommodations was a reversible error. And in light of Weisinger, it's at least possible that a trier of fact can find that in some circumstances, requests for help commuting could be a reasonable request for an accommodation. And I would point out, I was at a pre-hearing settlement conference at the State Personnel Board on this issue, and I cited those cases in my statement, and the administrative law judge from SPB said she read those cases and she agreed with my interpretation. And I think these cases also point out the problem about having blanket rules. And I wasn't going to address this, but I want to mention one more thing that Ms. Gomez spoke to about associational reasonable accommodation. So you have a right to California Family Rights Act or FMLA leave to take care of someone associated with a disability. And it's not settled law, but there are two cases that say it might be available as an accommodation under FEHA. It's my understanding that the Civil Rights Department is not accepting cases on that basis, but you still have the right to request a right to sue and challenge in court. And the two cases which talked about it, not as a firm holding, but in passing, one was Castro Ramirez versus Dependable Highway Express, a California case, which said we first observed that no California case has determined whether employers have a duty under FEHA to provide reasonable accommodations to an employee who's associated with a disabled person. But they look at the FEHA statute and note that under the statute, physical disability is defined not only as a person with a disability, but a person who is associated with a person who has or is perceived to have a disability. And there's a federal court that followed that reasoning also. So while it's not settled law, I think there are cases that do support that position. Thank you.
I didn't realize this will become a discussion of legal citation and authorities and case laws, but I appreciate the detailed response.
I hope that's okay. I want things to be more than just my opinion and I'm a lawyer, unfortunately. So sometimes that comes up.
I'm not going to hold you, liable for that. So thank you. So my next question goes to Christina. When employers request medical documentation during the interactive process, what are CRD's guidelines for appropriate versus excessive request? How should employers balance their need for verification with employee privacy rights, particularly for non-obvious disabilities?
This is a great question. Thank you. This is where a lot of employers go wrong. And they make really, really overbroad requests that can be inappropriate and expose them to additional liability. So I'll say first that there aren't any CRD developed guidelines. We're just looking at what the law says, what case law says. I also have the, unfortunate circumstance like Alan of being an attorney. And so citations we must live and die by. But that being said, there are guideposts that are provided in the law and through case law. Something that I think a lot of folks don't realize is that no specific diagnosis is actually required to be shared. I was a legal services attorney practicing in rural California. I never had a client whose employer was a doctor and could actually read medical records. So medical records themselves are often unnecessary and unhelpful because they're hard to understand for lay people. They also can be way over inclusive. So something like a blanket request for all medical records for a certain time period would be excessive, would be overbroad. These really, really need to be narrowly tailored, right? Think about the interactive, I was just talking about the interactive process, right? Think about what looking at a stack of medical records is going to do to the time that you have to respond, right? You may blow your opportunities to engage in a meaningful and effective and timely interactive process if you are laboring under a ream of medical documents that you're looking at that you can't understand because you're not a doctor. So I just want to make that clear. I said, may expose an employer to liability. Something I want, and this has come up before, a client of mine, this is something they had to think about. Providing all of their medical records in one of those really inappropriate blanket requests could capture information that is totally irrelevant to the reasonable accommodation, but that also could expose someone to discrimination or harassment or hostility at work. So think about someone whose reasonable accommodation has nothing to do with perhaps an STI that they have or that they had and that is in their medical record. So a sexually transmitted infection. Or if someone has HIV or AIDS and that is in their medical records, but has nothing to do with their accommodation request. Right? Those are the kinds of things that could come up and that could cause real issues for an employer who acts on those things or speaks on those things at work. So really, employers just have to ask for enough information to understand that the person has a disability that limits their major life activities and what kind of job-related activities are limited. It really just needs to be that. Things above that we are going to look at with scrutiny. Now, in terms of confidentiality, certainly employers have to keep medical information confidential. They can keep it away from the regular personnel file. That's a very good practice. But there are some examples of when employers may need to disclose those things. And if we think about it, these areas are common sense, right? So supervisors and managers who have to carry forward the accommodation, right? Maybe it's for flex time, for quiet time. And so their supervisor needs to be aware, hey, this person's using their quiet flex time, to be able to focus and concentrate, maybe away from the rest of the floor. First aid and safety personnel, right? Again, a common sense notion here, right? If that's related. Workers' compensation offices sometimes, government officials who are conducting audits for things like ADA or FEHA compliance. So there are some exceptions, but they're pretty straightforward. Other than those, an employer really, really needs to keep that information confidential, even when and even if another employee says, well, that's not fair. Well, what's that person got going on over there? I want that, right? Practicing that conversation, figuring out what the sort of party line is with your HR is really, really important so that you don't slip up and disclose someone's disability or their need for an accommodation. So think about those things on the front end. Preparation is everything with reasonable accommodations, because if you dawdle, if you flail, if you are splashing around in the water, unsure what to do, that could mean an undue delay. So even the best of intentions can create liability.
Thank you. I appreciate that. Eli, you're next. What documentation standards should departments follow when implementing interim telework arrangement, and how can they ensure compliance with both FEHA and ADA requirements throughout the process?
Thank you, Bobby. So I'm not too certain what you meant by documentation standards, but I'll take it as referring to, again, those involving people with disabilities and documentation related to an employee's disability. As Christina stated, it must be placed separately and not in the employee's official personnel file. And on the model statewide policy on RA, we have a particular section that actually speaks to this. And I'll just quote it. It says that reasonable accommodation confidential, shared only on a need-to-know basis. And we encourage individuals to connect with their HR officer, EO officer, records retention coordinator, or legal the documentation standards that their departments have. I would like to respond to some of the statements that Alan provided. And Alan, thank you so much for your wealth of knowledge in terms of case law. I'm actually going to email you because some of the case law you reference I've read and familiar with, but there are some that are new to me. So I would appreciate your assistance on that. And also, Alan, I do want to highlight the fact that you're instrumental in terms of many EEO and HR professionals across the state being inspired in terms of learning about Castro Ramirez. I bet you if you ask, many EEO professionals are now familiar with that case. So that being said, I do want to also acknowledge, Alan, what you stated about the case law and that currently it's unsettled as law. And I appreciate that statement very much that yes, case law does exist in regard to commuting and in terms of associational disability, but they are currently unsettled as law. And in the state, EO professionals, RA professionals, we still use the authority that are provided by the ADA and the FIHA. And currently, the FIHA defines RA is for the known physical or mental limitations of an applicant or an employee. I'm not an attorney, but I'm familiar that there's an actual government code specifically stating that. And then also in terms of the definition that the ADA provides for a person with a disability, a person who is either the disability, a history or record of the disability, or is regarded as having had such a disability. And in terms of RA analysis, the first two are the ones that critically come into play. And so although I personally empathize in regard to the movement, the assertion of granting RA for individuals for caregiving for other either family members, partners, or other individuals significant in their lives, it's currently unsupported by the FIHA and the ADA. And it may change, but currently, FMLA and other available options are the ones that may be applicable to employees who are caregiving or who may cite associational disability as the reason for requesting these accommodations. So just wanted to share those, especially since Rosa is unable to respond. I'm sure she's perfectly capable of responding, but I also wanted to provide CalHR's position on those matters. But thank you, Alan, for highlighting those.
Thank you, everyone. This is about the time I'm going to open it up for public input, take questions from the audience, and then go back to the question format if time allows. But I want to give the audience the opportunity to ask questions. Looks like we have a president of AAMSD raise his hand. Please go ahead, unmute, ask your question.
Thank you. Eli, just a quick question. So because there's precedent in law, again, I'm not a lawyer either, but since there's precedent in rulings in case law, or not actual law, but are you saying that you're suggesting that we have to go to court every time that a reasonable accommodation is denied for transportation purposes?
No, I'm not saying that. If you're denied, if your RA request is denied, your option is to file a complaint internally or with the state personnel board. And so these are the available options to you. And your department will have this spelled out in your EEO policy, and you may connect with your EEO officer to provide further explanation in regard to your options. And the SPB also has specific sections of their appeals manual explaining your rights in regard to when your RA request is denied. Again, it's not within my expertise or in my role at CalHR to advise anyone to go to court or not to go to court. That is your option. So that's our response to that. But thank you for that question.
Looks like we have S. Sharma has hand up. Please go ahead, unmute, ask your question.
Thank you all. It was so much educational. I'll come directly to the question, given the fact we have two attorneys and also Christina, Alan, Eli, Alex, Bobby, all of it. Thank you very much. Normally, and since you are the attorney, I'm bringing up that question. There are millions of examples in YouTube and internet. If an employee makes too much of wave, although retaliation is unlawful on paper, but oftentimes what will happen, the supervisor and manager, with the help of other administrator, will find out a way to put that employee on some sort of performance improvement plan, what is called PEEP. And like if you go right, you are wrong. If you go left, you are wrong. That kind of thing. And will essentially like write a corrective action memorandum or some sort of PEEP in the file to silently threaten that employee and silence them. And just look it up in the internet, you will find millions of those cases. So oftentimes, employees, they just choose to see no evil, hear no evil, speak no evil. So my question to you, all of you, is how can an employee feel safe knowing that they will have to walk on eggshells? Thank you.
Well, any panel member can respond to this if you like, or not.
It's a great question, and it's a very tough one. It's certainly something that is completely familiar to CRD. We enforce the Fair Employment and Housing Act, which does include retaliation prohibitions. But as the person who asked the question said, just because it's written in the law does not mean that folks are following it. I wouldn't have a job if that were the case. Although, one day I really hope that, civil rights is so scant that I put myself out of business. That would be incredible. That being said, how you can feel comfortable, that I can't speak to, because that's going to be something that's really, really individual with folks. But what I can tell you from my lawyer brain is how you can make your case stronger for a retaliation claim that might get you back pay, might get you reinstatement, might get you something else. So document the request, document when you made it, all subsequent contact, also every other conversation that you have, even if it's just in passing. Know and follow your workplace reasonable accommodation policy. Sometimes the interactive process ends up being a place where the employer clarifies because they don't understand the accommodation. An important piece of accommodation requests also is what's called the nexus, the connection between the disability-related need and the accommodation requested. I used to tell my clients, the straighter you can get the line from A to B, the stronger you can support that connection between your accommodation request and your disability-related need up front, right from the beginning. That's going to make everything a lot easier for you. And certainly if you're retaliated against or if there's an undue delay, you are in a much better position as an employee. Making sure it's clear, again, like in terms of what major life activity is limited, like I said, can help expedite that process. And I mean, for CRD, if a person wants to come to CRD, we try several times to get folks to engage in mediation, either informal mediation before we go down the whole road of an investigation, or mandatory mediation if we find that the elements are met and everyone is willing to come to the table. So we can get folks to do a lot of things in some of those settlements. And again, policy changes, monitoring, training for staff, because we're not just concerned with this sort of whack-a-mole of reasonable accommodation, retaliation, right? We want to make holistic changes at places so that they're not violating the law and so that their employees are feeling safe, are feeling supported. So there's a little bit of flexibility in our process that you may not find in court, although I completely understand why some folks may want to proceed to court and deal with it that way. There was a question in the chat earlier, and the person who asked it has not clarified, but the question was around like representing, CRD representing folks. CRD doesn't represent anybody. So when we take a case to court, we're taking it as CRD. We're not taking it on behalf of that person. So we're not representing that person. Although, you know, if we succeed and there are statutory damages, which is money that's required to be paid in a statute, the law says this amount of money has to be paid for that type of violation, that completely goes to the person whose rights were violated. CRD doesn't keep any of that money, even though we're not repping that person. So just want to, hopefully that's helpful. I don't know if that's the exact question that was being asked, but reading the tea leaves, that'll be my response.
If I might piggyback Christina's answer, one, CRD mediation, I recommend it to our members all the time. I've gotten some of my best results through CRD mediation. And I also agree that retaliation is very difficult to prove to establish that nexus. For example, if someone requests telework as an accommodation and a week later in office is required as an essential job function, that may be evidence of retaliation. And I would also argue that where you sit is not a job function. I mean, we can go to Webster's dictionary to look up function, but it's what you do when you're sitting. So I don't think if departments are trying to add that as an essential job function, I would definitely take issue with that. I don't think it's a function. I
want to piggyback on Christina and Alan's comments, and I agree. You know, and I want to highlight particular statements too in regard to. I mean, I personally I wish I could magically make people feel better. I wish I could magically assure people that yes, these protections are there and they will protect you. Absolutely. I do want to highlight resources, you know, not just for you, as Sharma, I'm sorry, I didn't get your first name, but also for the decision makers in terms of the resources you may utilize, you know, training, especially in terms of inclusivity, you know, diversity, equity, inclusivity, and accessibility, you know, as the foundation of a civil work environment. And that's why DEI programs are still very important. I'm not being political here. I'm being practical, in fact. And a psychologically safe work environment. And there are currently trainings that are available, individuals may take. And this is a great opportunity for decision makers to implement policies that would encourage, perhaps even require departments, you know, employees, groups, to take these courses to really set the foundation of civility in the workplace. Your EEO officer is there for you to consult with in regard to your concerns, especially if they fall under their area of your jurisdiction. And even if they don't, they are tempted to say supposed, and I'm just going to say it, supposed to advise you in regard to what your other options are. You know, we guide them. You know, we have resources we provide to EO officers to help guide employees. Also, this is also where Alex, Bobby, Alan importantly come into play. Your advocates, the union. You know, when you feel like internally you feel like there's an absence of support, reach out to your disability advisory committee, join the DAC, connect with your union representative to help assist you in processing these matters. And as Christina stated, document effectively. And make sure that you're able to establish that causal connection between what you may consider as retaliatory and the protected characteristic. You know, that is part of your responsibility to make that connection and to make your case stronger. So there are these options. And again, in the absence of my personal skills as a psychologist, because I'm not a psychologist either, it's these resources that I could offer you, hopefully to help you out.
All right, thank you. There is somebody, I'm going to come back to the president of AXME a little later. I've got someone from Rafael Serrano. Go ahead and ask your question.
Yes, thank you, everybody. Great meeting. This is for Civil Rights Department. Thank you for being here, Ms. Teixeira. Great information. Is there data available regarding how many complaints are filed or reports are filed with CRD from various departments? We'd be very curious to kind of access that data if it's at all available. Thank you.
Yeah, no, it's a good question. Obviously, we care very much about confidentiality, and so it's important to us to make sure that, you know, if we're providing data, right, that it's anonymized to the point where it's not going to out anybody. Back to the previous question about retaliation. But we do have annual reports that we publish every year that talk about the kinds of cases that we take on. It is not as granular as what you are asking. Who were the respondents? That is not something that you're going to find in the annual report, but I think at least looking at that kind of gives you a baseline for what it is that we're seeing. If you wanted to request that information, I am not sure if that would have to go through our Public Records Act unit, probably, but maybe not. That being said, because I don't know, let me be the one to close that gap. And if you email me, I will find out internally where that needs to be routed, if that can be responded to, and I will connect you with the right folks.
Thank you very much. I will do so. Thank you.
Sure thing. Thank you. No, I appreciate it. It's good for me to know too. This is all, all of the questions, the comments, I take that as feedback for the Civil Rights Department, right? How can we strengthen our information and our education? How can we make sure that folks are feeling supported? So I deeply appreciate it.
All right, thank you. I'm going to go to Evan, then I'm going to come back to the president of AXME. Evan, go ahead, unmute.
Hi, my question is on job duty statements. There's a work environment or physical abilities required that is after the essential job functions. And if it says may be required prolonged sitting or standing, is that considered part of the essential functions of the job, or is that a non-job related function? And how does that pertain to reasonable accommodations? Thank you.
I'm not sure if you asked anyone in particular. I would think it relates to what you're doing while you're sitting or standing. If you need to be standing to reach something, and then it might be related, although we once had a case where we got a mechanic with paraplegia, a stand and lift chair so that they could reach high things. But I think, I personally think the function is what you're doing when you're sitting or standing, not whether you're sitting or standing.
Yeah, this is an area, I'll say too, this is an area where we get questions. Oh, sorry. This is also an area where we get questions. And I think what the question is speaking to is essential functions versus marginal functions. So there are some functions of your job that are absolutely essential. That it's the main part of what you are doing at your job. And other functions are marginal, even though they are part of your job. But the law is very specific that reasonable accommodations are intended to help folks do the essential functions of their job. So you might be able to request a reasonable accommodation to modify those marginal functions or do away with some of those marginal functions, because we know that reasonable accommodations cannot be used to do away with essential functions, right? We've covered that throughout this call, and we know that. The law does not give hard and fast factors in terms of figuring out what's marginal versus, there's no prescribed list and this is it. But the law does provide some factors for figuring out whether or not those functions are marginal or whether or not they're essential. So like, is that what the job is intended for? Is this particular function something that's addressed in a performance review? What is the past experience of employees who performed that job? Right? What does the duty statement or advertisement say? Right? So all of those are different factors that have come up in regulations or through case law that help us understand what is essential and what is marginal. So I think that's really the place you got to start from. is like, what is this function? Because that's going to tell you whether or not you can ask for a reasonable accommodation and whether or not you can expect it to be granted.
Thank you, Christina. We're going to take two more questions and then we have to end this segment. I hate to do this, but we're running out of time. Before I get to the two that have their hands up, including President of ACME, I have a question that came on the chat privately. The question is for Christina. I received a right to sue letter from Merit Findings of Denial, RA discrimination retaliation in my case from Civil Rights Department, but my employer still continues to deny RA, forcing me to go on leave medical again. What good does it do if CRD doesn't represent me and my employer continues to deny RA? Retaliation, discrimination, what real enforcement accountability can CRD provide to hold them accountable? I filed EO complaint with the agency, but provided no relief, got no relief. So that's it.
Yeah, and thank you for sharing that experience. I understand that sharing this stuff, especially when it's frustrating, it can be even more frustrating, and it can make folks feel vulnerable. So first off, I want to say thank you for being willing to share and pose the question. That being said, I'll reiterate something. Actually, we don't represent anybody. So I'll say that again, right? We do not represent folks. So even if we, let's say hypothetically, even if that particular matter, of which I do not know the facts, even if that particular matter worked its way through CRD and CRD decided to, which we do in a small amount of cases, to take it to court, we still wouldn't be representing that person. If we didn't take it to court, that process that I described where we try to mediate informally and then mediate formally, that also is, is part of our larger process. We try to work something out there, but we wouldn't represent someone in that circumstance either. So in terms of representation, I just want to make sure that I'm clarifying that is not something that CRD does generally. So what I think the question is asking is, if all I'm doing is getting a right to sue and being told to go to court, then what is CRD good for? I think that's kind of what the question is getting at, which, hey, I appreciate that. I'll tell you on a personal note, the reason that I joined government is because I was on the outside banging on that door and didn't feel like I could get in. And now I'm inside and I understand a little bit more of the sort of the chains of review and interpretations, right? And these collaborations that we engage in with different departments. It's not a lack of desire on our part to help folks, certainly. There are some capacity issues and there may be some nuances to that case that I'm not aware of and that I frankly don't want to know about because it's confidential. I'll say though too, you can appeal, right? If you get a decision from CRD that you don't like, you can appeal. On the note of what else is CRD good for, we do a lot of education and outreach. And so part of what we hope to do is get out in front of some of these issues with employers. We can't always do that, but we develop guidance, we develop fact sheets, we provide webinars, we coordinate with other parts of the government, like the EEOC or the Department of Real Estate, to try to address these issues again, like in a more holistic way. So while we may not be meeting your needs via the complaint process, I can tell you from my perspective that we are deeply, deeply trying to meet those information and education needs. These folks here, y'all are very sophisticated. You know what you're talking about. Your state employees. Most of the people that CRD encounters are not sophisticated. They're not sure if they have a disability that qualifies or if they could get an accommodation. And so it's a challenge to make sure that we're supporting and reaching everybody, the sophisticated folks and then the folks that are a number of steps behind, the folks who are on this call. I'm sure that is deeply unsatisfying, and for that I apologize, but we are doing our best.
All right. Thank you, Christina. President of ACME, ask your question, please.
Yeah, it's in regards to retaliation. It's to my understanding that recently, as of January 1st, 2024, that the burden of proof is easier to substantiate within the first, I think, within the first little bit of the action, I think 90 days or so. And the burden of proof to say, hey, this is not retaliation is then on the employer. Is that still accurate, or did it recently change again?
Anyone from the panel?
I am vaguely aware of what you're talking about in terms of like a presumption, right? I used to practice housing law, and certainly that was true in housing law, that there was a presumption if someone was subjected to negative treatment within X amount of days of requesting like a repair or something of that nature. But beyond that, I am sorry, cannot speak to it.
And I'll say I'm not aware of any set number of days, but the timeline is important, and the sooner in time the alleged retaliatory act occurred, I think the stronger the case.
So I'm referring to Senate Bill 497. I don't know if anybody has, it's SB 497. If anybody has any, I thought during like research and whatnot that the burden of proof then becomes on the employer to say, hey, that we didn't retaliate. This is why X, Y, and Z. So it becomes easier for the employee to determine or establish retaliation.
Okay, I'm not going to put the panelists on the spot having to research a case that you just referred to.
No worries. Sorry about that.
The question, I will field it for them, get you an answer.
I took a quick look, and that's referring to the labor code, so I'm not sure if it would be the same type of presumption for FEHA.
Okay. All right. Hopefully that answers the question. I'm going to go to
sorry, I'll add, CRD, the Civil Rights Department, does not enforce the labor code. So to enforce the labor code, you would want to go to the Department of Industrial Relations.
Okay. All right. G is somebody who has a hand up. Please unmute, ask you a question. This is going to be the last question in this segment of.
Yes. Yes. Hi. Great training. I have a question for CRD, Christina. Sometimes your doctor writes a note, and it's only RA is needed for a temporary, like 3 weeks, 4 weeks. But by the time the employer gets to it, is long overdue. My question has 2-3 parts. So it's too late to grant RA because the time has passed, because the employer requested it to be done by this time, for example, for today, but they want to set up an interactive process after. By the time it just happens that way. My question is, can you file with the CRD even though RA was meant to be requested by the doctor on a temp basis? I am familiar with the internal process of my department. Now, my second question is for anybody who can answer this. When you don't, whether is an interactive process needed for a temp RA, when you don't set up that process in a very timely manner, is that some kind of violation of, I don't know, some regulation, a state ADA or so? That's all. Thank you.
To answer the question about whether or not you could file a complaint, certainly you could. Folks can always file complaints. And I don't mean to say that in a flippant way. What I want to say is that we don't expect people to be legal experts to file a complaint. You don't have to have an attorney and know all of the elements and be able to, make your claim with citations. We can't reasonably expect that of folks. And so if you feel like your rights have been violated, I'd encourage anybody to file a complaint with CRD.
Thank you. With that last word, I'm going to thank the panelists for your wonderful presentation. I wish we had more time. This is something that's so important to share this knowledge. I share with what Christina said. You want to empower people with knowledge. And that's what we try to do at SDAC as well. We want to be transparent, open, and share facts and not conflicts. And that's hopefully is what we try to achieve. That's not always possible with diversity of views, but nevertheless, that's our goal. So thank you again for all of you that have sat through this and paid attention to the panelists. My deepest gratitude for all the things that you've done and said today.